Thanks everyone for joining us today for about an hour-long variance basics training. This is a hopefully new and improved training. We had been doing a variance training for many years here, and we decided it was time to revamp it this year. And so we're looking forward to your feedback either at the end of this or through emails if you think you'd like to share something with us on how we can improve it. So I'm the Shoreline Program Manager. I've been at the DNR for nearly 15 years, and I have a background in local planning and zoning and have done planning and zoning before coming to the DNR for local governments in the metro area and counties as well. So that's me.
All right. Thanks, Dan. I'm Ricky Hoffman. Welcome to everybody. Thanks for jumping on this call. I am also with the DNR. I work as a supporting planner for Dan Petrik's program, the Shoreland program, as well as Seal Strauss's Floodplain program. Yeah, happy to be here. My background is also in local planning and zoning administration. I started my career for about a little over a decade in local government, county and city government, doing zoning administration. So I'm sorry if this topic is a little bit dry, but this is kind of the environment that I thrive in. So I'm happy to be here to kind of present on these things today. All right, moving on. So here's an overview of the agenda. The purpose today is to help you, provide you, best management practices to help develop better decisions related to local shoreline and floodplain variance requests that are supported by reasonable and ample findings or explanations grounded within purpose and intent of the regulations. We'll start with an overview of the purpose of the Shoreland program, and then we'll move into some variance basics. I will then hand it off to Dan, who will take you through an example variance and wrap up with some final considerations. I also have a note here at the bottom. I think it goes without saying, but this is intended to be a training to provide you best management practices in your local roles. But of course, this isn't a substitute for legal advice. Please we recommend maintaining a good relationship with your local legal counsel to work through and interpreting how local, state, and federal law applies. Before we dive into variance specifics and the example, we're going to talk just a little bit about the background of the purpose of the Shoreland program. So let's talk a little bit about that. So the DNR's role as it relates to variances, we'll get into, but for a little bit of background, we have shoreline standards today because of the implementation and the purposes of the 1969 Shoreland Management Act. This is sort of the basis for the framework that we still exist in today. This act acknowledged the value of the state's public waters and shoreline areas, and that they were important enough to protect through development regulations. The shoreline rules and by extension, local governments' shoreland ordinances protect these state-designated resources. These shoreland areas are intrinsically different from other zoning areas because shoreland areas provide water quality, habitat, recreation, and scenic benefits to all residents and as well as members of the public. Here up on the screen are sort of the purposes. The purpose of the Shoreland Management Act are, as you can see, threefold and are important to remember when considering variance decisions. As we'll talk about further on, the purpose of the particular regulation for which a variance is being sought is an important factor for a Board of Adjustment to consider when deliberating over the variance decision. I'll also mention, just as a quick aside, the purposes of the floodplain standards, that's sort of the sister program here that we're also talking within the framework of is, it's similar to the things up on the slide, but it also contains a significant life, health, and safety component to it. The state's floodplain standards are largely tied to the National Flood Insurance Program, and for these reasons, variances are very limited as they apply to local floodplain standards. So I just wanted to make that note in relation to floodplain ordinances as they relate to our discussion about shoreland ordinances as well. All right, the DNR's roles regarding variances. Our role is to ensure that shoreline and floodplain ordinances are administered in a way that achieves the purposes of state law. To this effort, we work in these three capacities. First, we offer technical support to assist in ordinance interpretation and offer design ideas. Both interpretation and design ideas may help avoid variances altogether or reduce the scope of the requested variance. Secondly, we comment on variances. There are many variances that we see every year, and we try to comment on those that undermine the intent of law and those with the largest impact. That's sort of our prioritization of commenting on those. Thirdly, we appeal poor variances decisions with large resource impacts which undermine the law and have poor findings as a general rule. All right, we're going to jump into some basics. As we roll out of the background of the Shoreland program and into variance specifics. So variances are exceptions to the literal zoning application, the ordinance requirements of the zoning ordinance. They are most practically viewed as a deviation from the ordinance requirements because most variances are not asking for an exception, but rather a deviation or relaxation of the requirement. Variances are allowed under Minnesota law to area or dimensional standards such as setbacks. However, many other standards such as land alteration and vegetation management standards also qualify for variances. With that said, state law specifically prohibits use variances. So for instance, one cannot request a variance to allow a use that's otherwise prohibited under a particular zoning district. Over time, state laws have evolved to recognize that one size fits all approach doesn't work for local zoning. Variances are a method to provide basic fairness to property owners and their wide range of physical situations so as to ensure reasonable use. If local regulations make land unusable, the local government is subject to regulatory takings and would need to compensate that property owner for that taking. So on this slide, we're using the graphic from the Minnesota League of Cities to set the stage for how Board of Adjustments make decisions on variances. This graphic, as you can see, shows a level of discretionary authority for different planning and zoning actions. At the very bottom, we have City Council and Board of Commissioners. They have significant discretion to make plans and laws through comprehensive planning efforts and enacting new and amended legislation. At the top of the pyramid are activities such as issuing building permits or zoning permits, where local governments have very little discretion. In this realm, if a building project or proposal meets the regulatory standards or codes, it must be approved. In the yellow middle zone is where applications require some discretion, and kind of what we're going to focus on today, such as variances, CUPs. They all fall kind of within that middle area. These applications require some level of discretion when evaluating whether or how applications comply with the local zoning code and comprehensive plan. This is where your Planning Commission or Board of Adjustment members play a quasi-judicial role. In this judge-like role, one is objectively gathering and evaluating facts and drawing conclusions from them to determine if a given application is consistent with the adopted plans and zoning code. In making a good variance decision, it's important that your Board of Adjustment follows important principles in making decisions. Facts can be many and varied and come in many different sources. In Shoreland, the impacts of water quality and habitat and character are relevant. The Board of Adjustment, acting in a role similar to a judge, must evaluate the presented facts using the statutory criteria. A Board of Adjustment should not have conversations with the applicant or members of the public. This is known as ex parte contact. They can only consider facts presented as part of the official process. Some localities call this the public record. Facts presented in official record given to all members of those presented at the public hearing. The Board of Adjustment cannot prejudge a decision. That's a really important point. They must wait to make a decision until all the facts have been presented. Prejudging a decision deprives the applicant and interested parties of due process. Decisions need to be in writing, thoroughly vetted, and clearly explained to why the decision was made. Presented facts and evidence must be used in an explanation, and simply repeating the statutory criteria is insufficient in this case. So here are some things that shouldn't be considered. There are things that commonly infiltrate the public hearing process. That they're not uncommon to hear these things in relation to a variance request or an anticipation of a public hearing or even during a public hearing. But the Board of Adjustment, it's important that they should not consider these things like neighbors' opinions, past practices used in previous public hearings, the applicant's reputation or personal needs, and economic circumstances. Here up on the screen, we've got the 5 statutory criteria posed as questions. The last 3 criteria on the screen are called the practical difficulties test. This criteria is the same for cities as it is counties. The law states that to approve the variance, all criteria must be satisfied. So if any of the 5 are not met, the variance cannot be approved. The decision quality by a board of adjustment is largely determined by how well they answer these 5 questions. And for the purposes of this training and the example that we go over, we're going to focus on the last 3, the practical difficulties test. Here's kind of a flow chart of decision making. The decision making process is sort of summed up in this slide. It's an oversimplification, admittedly, but again, I think a good visual. To make a decision, all criteria must be satisfied, or you must answer yes to the 5 questions. Well, you must satisfy the 5 questions. In some cases, a yes answer is technically a no answer, depending on how the criteria is written. You must address each criterion separately and explain how each is or is not satisfied. And lastly, the findings, which is just a fancy word for an explanation, is supported by facts. The resulting decision could be to approve with conditions, or deny. A bit of a plug again we've kind of been focusing on the Shoreland component or the Shoreland lens of our program, but a plug for the floodplain variances. In addition to those 5 statutory criteria that were just up on the screen, federal requirements also add these 3 components, and then state law also adds that final component. So just know these should show up if you've got an ordinance that reflects our current floodplain model ordinance. Your ordinance should reflect these standards, and you should be applying these when considering variances from your floodplain ordinance, which admittedly, again, as I mentioned earlier, shouldn't come up very often considering the nature of your floodplain standards. And in addition to that, here's a document that you can use if you're interested in getting some more FEMA guidance on variances in floodplain areas. And I think that wraps up my section. I'll let you go ahead and take it away, Dan.
Great. Thanks, Ricky. Once again, I'm Dan, and we're going to go through a variance example today and talk a bit more about the 3 practical difficulties criteria. As Ricky mentioned earlier, we're not going to touch on the first 2 that he shared with you earlier. We don't have enough time for that. So today, let's move on to our example. And we're going to make this extra challenging for you today. We're actually going to cover an example with 2 variances. We have a undeveloped, non-conforming shoreland lot, and this person would like to build a new structure. So this lot, while it's been around a very long time, has never been developed. And so this person is asking for 2 variances. One, they want to put their structure at 25 feet from the ordinary high water level instead of the required 75 feet. Now, placing a structure, in this case at 25 feet, also means they're putting the structure in what is known as a shore impact zone. Shore impact zone is always 50% of the setback, and it's intended in the shoreland rules or your ordinance to be a protected area where there is room left for vegetation, for filtering runoff, to provide vegetation for habitat, and to provide scenic character. So in this case, not only are they not meeting the setback, but they're also building in a very sensitive area where development is generally prohibited. The second variance they're asking for is to the impervious surface limit of 25%. Instead, they would like 37%. You'll notice at the top of the visual here that there's a road running through the lot. We have excluded that road from this calculation. It's sort of a de minimis issue here. It drains away from the riparian area. So we thought for purposes of simplicity, we'd just remove that impervious surface from the calculation because the owner really can't deal with that. It's just a given. So what we have is a large undeveloped, well, not super large, but it's an undeveloped non-conforming lot of 10,500 square feet instead of the required 20,000. At the shoreline area, we have a steep slope. It's a 35% slope, and it rises between the shoreline, and it rises 40 feet, or it goes 40 feet landward. It only rises 14 feet, therefore it's not technically a bluff, it's just a steep slope. And this person is proposing a 2,550 square foot walkout house, garage, and deck, and 1,410 square foot driveway. Now in the graphic, you'll see that the deck, which is outlined in bright red, is 25 feet from the water, and the house itself, represented by a dark red outline, is 35 feet. And that house is essentially parallel to the setbacks of the two adjacent structures. You can see the one on the right lot much easier than the one on the left lot, but they're both about 35 feet from the water. Now, both the adjacent lots were developed prior to the adoption by this community's shoreland ordinance. So they are considered legal non-conforming structures. And the lots, although all three of them do not meet the shoreland standards, are all legal non-conforming lots because they were platted before the local shoreland ordinance was adopted. So that is the case we're going to be looking at today. The first criteria we're going to look at under practical difficulties is unique circumstances. So in this case, the question is, are there unique circumstances to the property not created by the landowner? Now, when we think about that, there are some considerations, and these include a variety of property and topographical or physical considerations. We are usually talking about things like an odd-shaped lot or an odd-shaped or odd-sized existing building. Unique circumstances could also include the placement of existing structures, but they also include natural characteristics like steep slopes, wetland, vegetations, or depth to bedrock. When looking at natural characteristics, the important thing to consider is context. For example, there's a variety of things that I've highlighted here that are not unique in shoreland, and in fact, they're very common. And so we want you to be careful about how you think about unique circumstances. And as a point of contrast, here is an example on the screen of a lot that is actually, even by shoreland, a shoreland situation, considered fairly unique. We have this peninsula that is sticking out into a lake, which is surrounded by a river on two sides and the lake on the third side. And just you can see the odd shape of it. This is definitely a unique lot size and configuration, and its relationship to the water is also very unique. So, this might be a case where there really would be a unique circumstance due to the design or the configuration of the lot. So let's move on to the next slide here. One of the most important things to remember, though, is that the unique circumstance cannot be created by the landowner. Otherwise, there would be an incentive for property owners to proactively alter their property in such a way that would create unique circumstances. So, it's important to understand the history of when structures were placed and where were they approved, when were they done, in order to rule out any pre-made unique circumstances by the property owner. Also, it's important to think about the idea of feasible alternatives. This is a very good test to see if there are unique circumstances. So, the point of this graphic is to show that the person granted a variance to an ordinary high setback to build a house had alternatives further from the shore, represented by the yellow arrow. So in this case, this variance to build the house there really should not have been granted because there were not unique circumstances. It was purely a design preference. So that's kind of our basic overview of unique circumstances. And so let's look at a couple questions about this. So for the first variance, the ordinary high setback variance, are there unique circumstances not created by the landowner? And on the screen are two decisions, each one supported by a written finding. Now, granted, these are not very long findings, or in a presentation format here. In a real setting, you would provide much more detail, presumably for your findings. But take a look at both of these and decide which one you think is the best response for this criteria of unique circumstances. In this case here, the first item, both of these are good answers and findings because they rely on factual data. They are supporting themselves, with factual data, which is an important item for quality finding. As Ricky said earlier, we don't want to simply just repeat back what the criteria says. You want to say yes or no, and then we say yes because, and then you support it with some data and some good rationale. So in this case here, it looks like there are, it's fairly equal, and I think that sort of makes sense here because this is a challenging site. It is a pre-existing condition with these adjacent non-conforming structures fairly close to the water. So in this case, there are no right or wrong answers here. We're simply presenting these as a point of discussion and to look at some of the strengths and weaknesses in each of these potential responses. All right, let's look next at the impervious surface variance. And so in this case, are there unique circumstances not created by the landowner for the impervious surface requested variance? We may be coming to a settling point here. The no's definitely have it in this case here. And I think that might be because the option that says yes is sort of relies on some conjecture that you cannot build a contemporary house on a 10,500 square foot lot without exceeding the 25% coverage limit. I think this line of thinking undermines the shoreline regulations without considering that the size of this structure is driven by owner preferences, especially when no alternatives have been considered. The structures on both adjacent lots have smaller footprints and meet the impervious surface limit. So non-conforming lots are very common, and our hope is that communities will encourage property owners to meet the standards even on some of these non-conforming lots. The structure's footprint could certainly be reduced and go higher to achieve the desired living area, and the no answer supports that approach, and it specifically puts that line of reasoning clearly in the finding here. So I think this is a good decision. Like I said, there is no right or wrong one here. It's really how your community responds and how well you support that decision with findings. But I think the findings in the no decision are very strong. So, all right, let's move on to the next practical difficulties. So this one is essential character, and the question is, will the variance, if granted, alter the essential character of the locality? So this means usually it's really a concept of scale. Is the structure out of scale, out of place? Is it inconsistent with the surrounding area? But we also want you to think about, when you're in shoreland, that there are other things that fall into the essential character bucket. So one of the important things is, how does water flow through or over the site, and what impacts does the project have to water quality, habitat, vegetation, bluffs, or appearance from the water? Because these are all essential elements of the shoreland area, and when you develop in the shoreland area, you affect the essential character of shoreline characteristics in various ways. And so our example here, you can see how this large structure was built by clearing a lot of natural vegetation, altering the slope, putting in a lot of lawn. So this affects how water flows through the site. Over it, we've got a lot of lawn, which can carry nutrient-laden runoff directly into the water, which of course can cause algae to grow. And, growing algae is certainly a characteristic of some lakes and is part of the essential character. I think most people would prefer to not have it in their lake. So I think it's an important thing to consider. So let's think about these things and turn to our two questions. So the first question here is, will the ordinary high setback variance alter the essential character of the locality? Okay, it looks like we're starting to settle in here. Again, I think the yes answer uses factual details to support its decision. The no decision in this case is supported by comparing the subject structure to others on the lake, not the two smaller adjacent structures immediately next door. And it doesn't address impacts at all. So I think in this case, the yes version is a much better finding. Oftentimes we see earth tone colors used as, something that can support essential character, but while that's not unimportant, it's really not the only thing to be considered when you think about character, especially in a shoreland area where water flow and impact on vegetation are big factors affecting essential character. So, great. Let's look at the second variance now. And will the impervious surface variance alter the essential character? So I guess will this be satisfied or not? Let's see what you all think. Looks like it's pretty clear that you think that the essential character will be affected by the impervious surface variation. Again, a lot of data to support the yes answer, and this was kind of a red herring. No one really took it, but obviously the impervious surface isn't visible. But I'm glad that you didn't look at it that way and that looked at the other factors affecting water flow. And that's a great response. And I think it's important when you develop recommendations to Board of Adjustments, or even if you provide considerations, that you will help direct them in this way to think about the water and how it flows and how the vegetation and habitat is affected by potential variances. All right, we're on to the third and final criteria, reasonable manner. And so we want to think about the two variances. Do they put the property to use in a reasonable manner not permitted by the ordinance? To make a decision on this one, it's important to understand the purpose of the requirements the applicant is wanting to deviate from, because this criteria considers reasonable manner from the perspective of your ordinance, not what is reasonable to the property owner or to maybe just a casual observer of the situation. So let's look at what the purpose of the ordinances are for these two variances. So first of all, for the setback, under the shoreland rules, and if you look at the statement of need and reasonableness, or SONAR, which is a document that goes with the shoreland rules, the SONAR will explain the purpose of all the regulations in the shoreland program. And so if you're ever wondering how to tee up a staff report for your Board of Adjustment, you can always reference the SONAR document, and we have that on our website. But in this case, we have a setback standard to maintain space near the shore so that there's room for vegetation, nutrient infiltration, habitat, and of course, lakeshore character. The setback helps to reduce the visibility of structures from the lake. And so we have setbacks that vary depending on the classification of the lake. And so in this case, we have a general development lake. The riparian setback is 75 feet. And now for impervious surface. Again, the reason we limit it to 25% is to limit the amount of runoff that can come into surface waters off of impervious surface. And we just simply want to retain most of the lot for vegetation, again, for habitat screening and nutrient infiltration. So when people talk about how they might mitigate impervious surface with permeable pavement, it's important to remember that the purpose for this limit is more than just a stormwater best management practice. It's also about simply retaining vegetation for habitat screening and nutrient filtration. So, please, hopefully you can avoid the temptation to try to engineer a mitigation to this particular standard, and try to think about the impacts to these other reasons if a variance were to be approved. And there's one more slide. It's just a reminder here to explain the purposes of the ordinances that someone is requesting to deviate from. And so just a reminder, if you can, to put in your staff reports the reason that we have these particular standards. That will give your Board of Adjustment the ability to carefully consider impacts and ultimately a decision. So let's go on and have you weigh in on the last two questions. So in this case, does the ordinary high setback variance use the property in a reasonable manner not permitted by the ordinance? This is pretty amazing. Okay, I'm glad to see we have a few people who are willing to challenge convention here. Okay, so both answers here, I think, are legitimate. The idea here behind yes, it is reasonable to have relatively unimpeded views of the lake, not obstructed by existing adjacent structures, is rooted in a regulation that the shoreline rules have, where you can use setback averaging for infill lots. Now, that wasn't an option in this case because this has to do with a non-conforming lot, and state law does not allow you to build on a non-conforming lot if you can't meet setbacks or the impervious surface limit. So in this case, a variance process was absolutely required. But if this person was willing to develop this lot with and meet the setbacks and the impervious surface limits, they wouldn't have needed a variance, and they could have just built at the setback averaging provision allowed in lot. So if this had been, just sort of a run-of-the-mill application without requiring variances for impervious surface, they could have met the setback averaging provision. So, but anyway, I don't want to worry too much about that here. I was really just interested more in the thought process and how you might respond to some of the findings. And in this case here, I think the findings for no are stronger. The yes one is a fairly weak finding, but in a different situation where somebody didn't need an impervious surface variance, the shoreland rule provision to allow setback averaging could have been allowed, and they could have built the structure at least with the deck being at 35 feet. They couldn't have built at 25 feet because that would have been in front of the average setback. Let's look at just the last one here. How does the impervious surface variance use the property in a reasonable manner not permitted by the ordinance? Looks like here clearly hands down no response. The no response is really a good response here because the findings specifically deal with the impacts or the fact that the owner hasn't addressed the various impacts to the purpose of this particular provision, dealing with of water flow, infiltrating water, dealing with sort of the impacts of nutrients going into surface waters. So the no has a very strong finding. In this case, I think it would be tough to answer yes, even with some good findings, because relating to other contemporary developments isn't a very satisfactory response. It's sort of something that could be given in almost every situation. without a lot of factual detail. So in this case here, I just wanted to let you know this was based on a real variance decision. Ultimately, in this case, the community approved both variances, but they had a number of conditions that modify the original proposal. And so we'll talk about those in just a minute here. We want to just get on with some one other housekeeping issue, and then we'll talk about some conditions and a few remaining facts. So when you're looking at a variance application, I think the most important thing is to just step back and ask, why is this person asking for a variance? If the variance provides sort of minimal relief or just it's a minimal deviation, that's one thing versus a significant deviation. And then secondly, has the applicant demonstrated that there aren't any feasible alternatives? If the answer is no in both of these questions here, a design preference, not a practical difficulty, is likely driving the need for a variance. And as staff, I think you can use your staff reports to sort of reveal these two situations without giving a specific recommendation if that isn't how your community works. But I think it's important certainly to ask about feasible alternatives and ask them even during a pre-application meeting if there's ways that they could modify the design in order to prevent the variance application altogether or to minimize the impact. And so I know many communities do have pre-application meetings with applicants to try to minimize or eliminate the need for variances. And if you don't do that, I'd recommend that you think about that. Let's move on. We just have a few remaining topics left here. And the first one are conditions, are ways to minimize impacts to lakes and their shorelands. Minnesota allows communities to impose conditions if the conditions are directly related and roughly proportional to the impact created by the variance. And so these two concepts, directly related and roughly proportional, come from two key Supreme Court cases. Directly related is also known as the essential nexus case, and it comes from the Nolan versus California Coastal Commission case. And the rough proportionality idea comes from the Dolan versus the City of Tigard case. These are both well-known cases. If you're not familiar with them, I certainly would recommend you look them up. They were really seminal and really affect how you make permit decisions and put on conditions on not only in variances, but on conditional use permits, plats, almost any sort of permit. You need to make sure that the conditions are directly related and proportional. This question is an open-ended question for you. We're just looking for your big picture ideas that if the ordinary high setback variance were approved, what conditions do you think would be reasonable to add? All right, so I'm seeing a lot of things about adding vegetative cover, screening, some erosion control measures, a bond, financial bond in case things go wrong, collection of roof runoff water, native plants. So yes, these are all great ideas. One of the impacts from approving a setback variance is the visual character of the house is very obvious unless you have some vegetative screening. We talked about the fact that there's a steep slope between this proposed structure's location and the water that wasn't vegetated or minimally so. So planting vegetation on that steep slope, collecting roof water, yes. These were actually all conditions of approval from this actual case. And so there was a requirement to vegetate the slope, to direct all the rainwater to the rear of the property, and actually to put some vegetation screening in between this property and the adjacent properties. So all good ideas, all relevant to this particular situation. So, okay, what about ideas you might have for conditions dealing with an approved impervious surface variance? Rain gardens, impervious pavers, stormwater pollution prevention plan, treatment of impervious exceeding 25%, directing runoff to the road ditch, rain gardens, vegetative buffers, infiltration swell, green roof. Again, these are good ideas. In this case, it doesn't look like anybody mentioned shrinking the impervious surface, which was actually a condition required by the community that had this variance. They actually required them to reduce the size of their driveway, which I think makes sense. Certainly using permeable pavement was part of the solution, but that again takes up space and removes space for vegetation. But again, these are really good ideas that could be considered. We have to go to the extra mile here and figure out, are they roughly proportional to the size of the variance granted and the impact. But that's a discussion. That's a more detailed discussion than we have time for today. So, okay. Last few closing thoughts. Just wanted to point out that under state law, it requires, or it does provide support to local governments to require mandatory conditions or mitigations for variances. In these cases, the law states that property owners must address, when appropriate, stormwater runoff management, reducing impervious surface, increasing setback, restoring wetlands, adding vegetative buffers, so on and so forth. And these are things that you just mentioned as potential conditions. So you're certainly in line with what state law allows you to do. It's in some smaller communities, boards of adjustments feel very bashful about requiring conditions. And so the point of this slide is just to remind them that state law gives them permission to do so. Moving on, in the Shoreland area specifically, our Shoreland rules do require compliance, septic system compliance whenever a permit or variance is required. So in today's terminology, an ISTS certificate of compliance would be needed to approve a variance. If a septic system was non-conforming due to insufficient setback, that is still acceptable and not considered non-compliant. But it has to be a functioning system. It has to be able to treat sewage in compliance with PCA's requirements. And so this is an element of the Shoreland rules that many communities forget. And so we're just reminding you that it is in your ordinance. So take a look if you're not familiar with it. And then also, if you're a county, boards of adjustment may request applicants to demonstrate the nature and extent of any adverse impact on the environment. So again, state law gives boards of adjustments the permission to tell applicants, we are not comfortable with the level of impact or how you're presenting your proposal with regard to potential impacts. We want you to go back and answer our questions and come back next month, until you can, so we can look at this again. And so it's an opportunity to table or continue a topic to a future meeting until there is sufficient information to address concerns that the Board of Adjustment might have. And then very lastly, we just want to remind you that there are notifications that you're required to give to us. We need a 10-day notification before the public hearing, and we need to know within 10 days of your decision, hopefully with findings. And that's our way of sort of staying on top of what local governments are doing in terms of impacts to shoreland. And so that's what we have for you today.